I'm Dave Seglins, and this is the Current Podcast.
It's essential in a world that we live in when we know we all walk around with phones in our pockets that are incredibly powerful, that create access to artificial intelligence, modern tools that certainly have benefits for society, that we recognize at the same time it creates potential for abuse.
That was Federal Justice Minister Sean Fraser speaking late last year about the problem of sexually explicit deepfakes. At the time, Fraser announced the government's plan to fix a gap in the criminal code and make these images illegal. Well, several months later, advocates say victims are still not protected. Earlier this week, a Nova Scotia man who used AI to create nude images of his classmates was acquitted of some charges because of that gap in the law. Blair Rhodes is a reporter with CBC News who's been following the case. I spoke to him earlier this morning from Halifax. What exactly was this man accused of doing?
Well, he went on social media, including Facebook, and found pictures of the 5 women that he knew. The pictures themselves were innocent, at least in the beginning, but then he applied some software that he had to create what, as you refer to, deep fakes or intimate images, in which, in the judge's words, nude images with up-close, realistic, easily visible breasts and genitalia imposed on the real faces of these complainants. So these were not artistic nudes.
And I understand he then shared them back to them?
Yeah, I think that's what got him in trouble. He sent them copies of his handiwork, and that resulted in the charges under the intimate images provisions of the criminal code. But he was also charged with criminal harassment and sending an obscene picture. He pleaded guilty to both of those charges. The only thing that was being settled in court was the whole question of whether these images met the intimate images test in the criminal code.
So what exactly was the decision?
The decision was that they did not meet the test. There is a quote from Judge Bronwyn Duffy, that I think really sets it up. She says, "The law does not reflect the technology that exists today, and to combat advancing technologies in the commission of offences requires the dictates of Parliament. It is not within the proper jurisdiction of this court to extend the reach of the legislation to include an image that creates a nude body entirely generated by AI using a real identifiable face of a person as a visual recording of a person within the definition of intimate image." Judge went on to acknowledge that these women had their privacy invaded. It was no doubt very troubling for them, but it did not meet the test under the law.
So what exactly is the gap here? I mean, if he pleaded guilty and gets convicted for harassment and obscenity, what is the added challenge for this intimate images legislation that exists if these pictures had been real?
I think the way the judge explained it was the fact that they weren't real. They were deep fakes, as you said in the introduction, and that, I guess, is the hill that they have to climb over in order to get a conviction. And she said, look, I'm not going to try and reinterpret or extend the reach of the law. The law, as it is currently constituted, does not make it. She looked at the history of this. She talked about how the Online Harms Act was introduced in February of 2024, but died on the order paper. So the government, as Justice Minister Fraser said in the introduction, acknowledged there was a problem, said they were going to fix it, but haven't gotten around to it yet.
Let's get back to the case for a moment. There's a publication ban on the names of the victims and this man, but what do we know about them?
All 6 of them attended a Halifax area high school. They were in the IB program. That's the International Baccalaureate program. It's an intensive academic university prep program. However, the charges are more recent. They're only in the last 2 or 3 years. So they graduated in 2018. They're all in their mid-20s now. And the offenses that he is accused of occurred long after they'd graduated from high school. But that was the common denominator, that he knew them through school. The judge was at pains to point out that they weren't friends. I would suggest that they're probably even less friendly now after this episode.
I can imagine. So if there is not a finding and the judge rules that because these weren't real, they don't constitute intimate images. I mean, have we seen cases like this in the past?
Yes, this is a very tricky area of law. There has been a few of these cases that have come up, and frequently they die on the same grounds. That the definition is hard to pin down. It does not keep pace with evolving technology. And I mean, there was one case here in Nova Scotia that was perhaps the founding of this all back in 2013, Rehtaeh Parsons, who was bullied and harassed because of an intimate image that was posted of her. And there was a great outcry, and the province actually tried to come up with legislation. But that legislation, like many things conceived in haste and anger, did not survive its first legal test because it didn't comply with the charter. So this has been a problem that's been around for a long time. And the longer it drags out, of course, the more the technology keeps evolving, keeps moving the goalposts that parliamentarians have to try to reach in order to make sure that people are protected.
What's the Department of Justice said about this case?
All I've got in my queries about this is crickets. I put in a couple of requests this week. I think somewhat ironically, the first and only reply I got was probably generated by AI. Thank you for your query. We will get back to you as soon as possible. That was 2 days ago, and that was the second time I'd reached out to them. So I'm not sure. Maybe if they're listening this morning, they'll get around to answering me.
In your mind, as a journalist and layperson, I mean, what do you see as the biggest challenge for lawmakers in trying to prohibit the deep fake problem of intimate images?
Well, there's a balancing act there because the charter is also there. You can't get too draconian in the laws that you impose. But I'm speaking, as a father of 2 daughters, there's no way I want to know that this is even possible out there. And as it's currently constituted, it is. And as this case seems to demonstrate, they can get away with it. So, clearly the gap has to be filled. The legislation that has been promised, that has actually made it as far as the order paper, needs to be pushed through. And I don't know, maybe it isn't a priority at this time, but there's clearly a problem. I've heard from people, including women's groups, since I put this story out, since the court decision was released earlier this week, who have voiced their frustration because they have been carrying this torch a lot longer than this story and this court case, and they're frustrated that they haven't seen any action.
And I understand that sentencing on the harassment and obscenity part has not occurred, but what kind of punishment is this person, despite being acquitted on intimate images, what kind of punishment is this perpetrator facing?
It's hard to say. Judges like to say that sentencing is an individual act. This was obviously on hold while they awaited the ruling on the intimate images component of the charges, because it would have been much more serious had he been convicted on all of those. If I would hazard a guess based on my experience in the courtroom covering cases, if he gets jail time, it wouldn't be that much. It could also be diversion, because while these are obviously very troubling charges for the women who were targeted, it's at the lower end of the scale in terms of offenses that courts have to deal with.
All right, Blair, we'll leave it there. Thank you very much.
You're welcome, Dave.
That's Blair Rhodes, a reporter with CBC News in Nova Scotia. Well, Suzie Dunn is an assistant professor of law and the director of the Law and Technology Institute at Dalhousie University. She joins us on the line. Professor Dunn, hello.
Hi, good morning.
What do you make of the judge's decision in this case?
I think the judge was in a really difficult spot in this case. You could read from the language of Justice Duffy that she recognized this was a really terrible privacy harm. It impacted these women's sexual integrity in a really serious way. But law is about reading words and reading language, and the thing that she got a bit stuck on and had to make this decision on was this idea of whether it was a visual recording or not. And I think because the current federal government is proposing to add a new criminalization of deepfakes, there was a suggestion that it wasn't included in the current definition. And so because of that, on her reading of the law, she wasn't able to find a conviction there. So I think it was a challenging case. I think it's a case where it's a real social wrong, but there is a gap in the law.
Do you think it's the right decision given where the law's at right now?
I think that there was an opportunity where it could have been interpreted slightly differently. I think that the intention of the lawmakers at the time was to protect people from their intimate images being shared without consent. But the challenge is that when the law was made in 2015, deepfakes weren't around. They weren't around until 2017. So you see in the civil statutes that we have for intimate image protections, they've started to shift their language to include explicit language on deepfakes. But a lot of police were struggling, judges were struggling. Does it fit within the current definition? And I think on a plain reading of the law, the judge likely got it correct in this circumstance, though it was open to interpretation.
But it's not a visual recording of a real thing necessarily. It's a abstraction or a artificial creation.
Exactly. And if you look in other areas of law where we do criminalize other forms of sexual images, so for example, in child sexual abuse material, a deepfake is included in that content, but the language in that definition calls it a visual representation of someone who is or is depicted as, rather than a recording where someone's sexual organs are exposed in a particular way. So this is the challenge with the law, where we're really nitpicking around language.
In this case, there were classmates who were victims here. What do we know about the impact on the victims when this kind of material is created and published or disseminated?
Oh, the research shows that the experience, the mental harm experience, the trauma that can be experienced is similar to people who experience sexual assaults. And the harm when these images get released, the social impacts, the reputational impacts are really significant. But I think the core thing that we need to focus in on here is the fact that these women lost their ability to control how they're sexually represented online. And that's something that I think what the government needs to protect. We should always have total control over how our sexual bodies are represented digitally.
What kind of protections are there currently for people who've had these images made of them?
So it depends on the province that you're in. So provincially, there's many civil statutes out there, which is when you can sue someone rather than going to the police. But depending on the province that you're in, the definition is different. So here in Nova Scotia, we have a definition that's similar to the criminal definition, which is open to interpretation. But our civil statute also includes cyberbullying. So, it could fit under a form of cyberbullying. But in other provinces like British Columbia, they include fake images and altered images in their definition of intimate image. So you can go there. They actually have a really convenient civil resolution tribunal. You can go to it without a lawyer, and you can get court orders for those images to be deleted and taken down, which is primarily what a lot of the victims in this situation want.
I think a lot of people would have heard about this idea in high-profile cases of celebrities' images being used in this way. Mm-hmm. What do we know about how pervasive this phenomenon is more generally?
Yeah, so it's been around for over a decade now. And initially when the technology came out, it was open access, so people who were good with computers could figure out how to make it, but it was still quite difficult to make a deep fake, and this is why you primarily saw people making images of celebrities, but those were still in the hundreds of thousands of images that were being created. Now that you have this deep nude technology, which is the technology that was used in this case, where you can take a single image, put it into an app, and then boom, you got a naked image. Now we're seeing images in the hundreds of thousands being made per month, per year, and we see a lot more everyday people being targeted.
What could the consequences be for social media companies that don't take action on these kinds of issues?
Yeah, so that's a third area of law, right? We think about criminalizing deepfakes. There's civil laws where you can sue, and then there's this larger question: should we be regulating social media companies so they're required to take this type of content down? So that's what the online harms bill was, and in that bill, they had a requirement that social media companies, once they were alerted to these images, would have to take them down within a 24-hour period. And because we don't have that type of legislation, you see things like what was happening on Grok in the last few months, where there's a real permissiveness to undress and nudify people on social media platforms with very little recourse.
You've said that this is important to think about as a gender equity issue. Can you explain a little bit what you mean by that?
Yeah, so although men are targeted by this type of harm, and research shows that self-reporting, there's high numbers of men who are also targeted by this harm. But if you look at public-facing deepfakes, they're primarily made of women. And even the technology itself is sometimes limited to women's bodies. So some of the deep nude apps, if you were to put a picture of a man into it, it would actually only produce a naked female body. Like, it's only meant to produce that. So we know that there's a gendered element to this. And also when we look at the impacts of what happens to women when sexual images are put out of them without their consent, the social consequences that they face are much higher than what we see for men and boys, which can still be high. Like, I think this technology, it's not totally gendered, but there is a largely gendered element.
So if you were to fix this, what are some of the challenges when it comes to creating legislation that's actually going to be effective?
I think it's about timing. I think that when we look at what's happening in BC, where they have a fast track option where you can get a quick court order, I think that's very important. And then I think regulating social media companies so the content is removed very quickly. In this case, the women had the photos shared to them on private messaging, but often this content is online. And if you don't get it taken down right away, it's so easy to copy. It's so easy to replicate. And for some women, this imagery will come up for the rest of their lives, and they'll have to spend the rest of their lives chasing it down and trying to get it deleted.
Also chasing it down are governments. I mean, they're trying to create policy that's, constantly having to keep up with an evolving technology. I mean, how can governments keep up?
Oh, well, I think it's about the language of the legislation, right? Like, I think the challenge here was that, in the current law, the criminal law, we said visual recording, right? Because they were thinking about cameras, they were thinking about video recorders. But I think when we're crafting laws, we need to make sure that the government is focusing on the harm and not so much the actual technology, right? So this harm is when people are creating and distributing realistic-looking images of a person who's nude or in sexual activities. So that's the way that laws should be crafted, so that they're broadly applicable to this particular type of harm, rather than saying, deepfakes are illegal. So I think trying to keep the language broad enough so that we don't trap ourselves, because, who knows what's coming. We know that there's holograms, there's VR sexualized video games, there's all sorts of new technologies that will be coming out that we want to make sure is captured in this law, because when we think about deepfakes, no one knew that was coming.
What should the consequence be for somebody convicted of this kind of offense?
A lot of the focus of my research is looking on the remedy rather than the consequence. I think what we want in these circumstances is that we want people to be able to live well with good sexual integrity, and we want people's behaviors to change. So I think it's most important that we get the remedies that people want, which is content taken down, not having these apps available to people. And then I think we need to really focus on perpetrators. So right now, when young boys read the news and they say, oh, it's not illegal to make and share a deepfake, that's really shifting social norms. So I think one of the focuses that we should have, rather than saying, let's punish these guys, let's put them in jail for a long time so that they learn their lesson, it's like, how could we talk to men, like the men in this case, and other people who are creating this content, to change their behavior, to have them respect people's sexual integrity?
Professor Dunn, we'll leave it there. Thank you very much.
Great, thank you.
Suzie Dunn is an assistant professor of law and the director of the Law and Technology Institute at Dalhousie University.